Hello there, I'm Robert Bond. I'm a partner with Bristows, and I wanted to talk to you in the next few minutes about the EU General Data Protection Regulation, which has less than 1 year to go before it comes into force. I want to tell you why the regulation will be important to you and your business, and leave you with some thoughts as to what you should be doing with less than 1 year to go. So the General Data Protection Regulation is probably the biggest change in our data protection laws across Europe for the last 20 years. It will affect businesses in the UK even when we have Brexited. So what are the key points from the General Data Protection Regulation, which I keep referring to as GDPR? Well, firstly, it applies to both data controllers and data processors. Data controllers are businesses that make decisions in relation to personal data, and data processors are third parties who carry out processing activities on the instructions of a data controller. So for all businesses that are processing staff data, customer data, supplier data, data for marketing and so on, they will be caught by the GDPR. And for those third-party vendors that manage annual appraisals, or data centers, or call centers, or any other social media platforms, for example, that are processing for third parties, they will be processing for data controllers, they will be caught by GDPR. Another important issue is that it won't matter where you are as a controller or a processor in the world, but if you are actively processing EU citizens' data, or you're carrying out profiling about EU citizens, then you will be caught by GDPR, and you're going to have to think, without an EU presence, who will be your representative to sit between you and the data protection regulators across the EU. We've heard a lot already about consent being a very key issue for GDPR, that consent will be more explicit, that the language for consent will have to be plain and simple and intelligible, and also in language capable of being understood by children if the data that is being processed relates to children. But we mustn't forget that there are a number of lawful means of processing personal data, and GDPR, whilst it talks about consent, also talks about vital interests of the individual, contractual necessity, public tasks, but also legitimate interests. And I wanted for a few minutes to remind you that it may be advantageous for your business to look carefully as to whether or not you can rely on legitimate interest as a means for lawfully processing personal data, so that you don't need consent of the individual. It doesn't mean that legitimate interest is a get-out-of-jail-free card, but it does mean that if you can carry out a balancing test and come to the conclusion that your legitimate interests in processing personal data do not outweigh the rights of the individual, then you could, for example, rely on legitimate interest for anti-fraud activities, or some aspects of direct marketing, or background checks, or the exchange of data in the course of a merger or an acquisition that, say, relates to customers, suppliers and employees, where the last thing that you'll want to do is to get consent. Then we also need to remember that there will be a one-stop shop under GDPR, so that if you happen to be operating in 28 member states, whereas currently you have to deal with 28 member state regulators, under GDPR you will only have to deal with the data protection authority in the member state where you have your main EU operation. So you need to think carefully, both now, before Brexit, and after Brexit, where will be your key EU operation, and which regulator would you want to be dealing with, because there might be an opportunity to consider some forum shopping around which is your main EU operation. One of the other areas we've heard a lot about is the increased enforcement and fines under GDPR, up to 4% of global annual turnover or global annual revenues for some of the more egregious non-compliance. And whilst we don't think that 4% is going to be immediately levied, we certainly do expect to see regulators taking a more aggressive position towards businesses that don't comply or won't comply. There's also a whole range of new items defined as personal data. All the usual things that you would have expected, such as names, addresses, date of birth and so on, but also genetic data, biometric data, children's data, and IP addresses, Internet Protocol addresses, will be personal data. So you're going to have to think very carefully how much personal data you're processing and how you obtained it and what further permissions you may need in order to carry out the activities that you'll need to carry out. One of the other items under GDPR is that for larger businesses or businesses that process large volumes of data about individuals on a systematic basis or carry out regular profiling of data subjects, they will have to appoint a mandatory data protection officer who will have to be suitably trained, have technical and legal expertise, not have conflicts of interest, be able to report to the highest authority in the organisation. And this will place some stresses on a lot of businesses in trying to find that individual, and also ensuring that they are not conflicted in the way that they carry out their roles. And the roles of the DPO are quite significant in that they genuinely need to be involved in a whole range of activities, including privacy impact assessments, another requirement of GDPR, and the implementation of privacy by default or privacy by design. And finally, we also need to remember that data subjects will have enhanced rights under GDPR, such as the right of portability, the right of erasure or the right to be forgotten, and the right to understand automated decision-making or profiling. So what do you need to do with less than a year to go? Well, first of all, you need to carry out an exercise to map your data estate. Understand what data you've got, how sensitive is the data that you have, how long have you held it, do you really need it, what permissions did you have for the use of the data today, not when you first obtained it. Do you collect data from third parties? Are you getting representations and warranties from third parties that they have the necessary permissions to give you the data? You're going to need to consider, do we need a data protection officer? Do we know what privacy impact assessments look like? What are the lawful grounds that we rely on for processing data? Is it consent? Is it legitimate interest? Is it vital interest, contractual rights, and so on? You're going to need to know how you would manage data breaches. Data breaches have their own rules under the GDPR, and you're going to think, who will be the regulator that we have to report to when things go wrong? Above all, the one thing that you must not do is sit on your hands. Doing nothing is no longer an option. The regulators are making that quite clear. And as I said earlier on, the more that you can show that you are moving in the right direction, the more that the regulators are going to focus less on you and more on those that don't comply or won't comply. So please take the right steps. With less than 1 year to go, there's not a lot of time. Thank you.